on an email discussion today about DNS blocking that's going to be happening in Canada. In Canada, our gambling is a government-owned monopoly, and to prevent citizens in a particular province in Canada from accessing online gambling sites that aren't the ones owned by that provincial government, the government is about to begin DNS blocking to ensure that they can keep holding that monopoly. Bill, I don't know if you're aware of this, or yeah, and that's happening as we speak. It's moving operational this week. So we see it in our space. We don't believe that the internet should be used as the mechanism to enforce what are essentially behaviors, right? To use the big stick that would be DNS blocking, or to extend that control over the DNS DNS is a global resource. To exert your national sovereignty over what is essentially a global resource has consequences, from fragmentation to instability of the internet. And while there are instances where DNS blocking or taking a TLD out of the root is warranted, primarily for technical issues, to mitigate damage, potential damage from botnets, to do so to change or stop essentially a behavior is simply not acceptable.
So in order to help frame the discussion, what has emerged in this first comment is a word that is important and that we'll use and explore more is the notion of sovereignty, because jurisdiction is basically also a code word and an illustration of sovereignty. Second element that you highlighted is the notion of the DNS layer, i.e. the domain name system, a technical layer of the internet, and its relation potentially to the activities that people are doing on the internet, and whether it's an appropriate tool or not, and in which conditions, to act at the DNS layer to address something that is a behavior. So just to frame. Going to Will next, was from Google. Can you tell us how you see this perspective? And there were many workshops on the famous right to be de-indexed, where the question of jurisdiction is coming into play. Can you tell us how you see it from an online platform perspective?
Right. So thanks.
And search engine.
Right. And do it all in 1 minute.
Yeah.
So as Bertrand said, my name is Will Hudson, and I'm with Google. And I mean, I think, I agree with everything that's been said already. I think that one of the things that sometimes gets lost, right, is what we're talking about here, right? What the internet is obviously has a technical component, but it also obviously has a social, political, and economic component. And as it's one of the reasons why, we need to get everyone online, not just some people online, and get them online everywhere. And as more people get online, this fundamental problem that we're talking about here, which is sort of the how do concepts like sovereignty, how do concepts like domestic law intersect with an increasingly connected world, right? So you can go now online. Google's one of several companies that publishes a transparency report that talks about the volume and trends of government access, government request access, our users' data, and other categories of information. And you can see that the trend line is going up. It's going to continue to go up, and it's going up for the very simple reason that there's simply more and more data and more people online. And I think one of the great things about this project in particular is, when you're looking at that, I'm here from Google, and I think, a natural reaction, it's not an unreasonable reaction, is, Google, throw more resources at the problem. You need to, you can ramp up and deal with this. And I think, that's an understandable argument. But I think that what often gets lost is, again, my first point, that what we're talking about with the internet isn't just an engine for economic opportunity for, established companies, but it's to let, small and medium and individual people begin to compete and begin to communicate with one another, do businesses in ways that were simply impossible 20 years ago. And when you're looking at this problem and you're thinking about, how, if I'm a small company or if I want to do a startup, do I enter this world in a place where chances are non-zero that at some point someone either using my platform for something will do something that will be of interest to law enforcement, right?
In another country also.
In another country, because everything is connected, and more people will be online in more and more places. And so the fundamental reality is we have to find a way to deal with this issue that doesn't just work for the established companies, but also works for people joining this platform for the first time. And I think it's one of the great strengths of this project that it's looking at that challenge head on. So.
Well, just one thing, if you can highlight for people who are not familiar with this. I was mentioning the right to be de-indexed, and as a search engine, you're in a situation where there are two arguments that go in opposite directions. One is to say it is the implementation of a European law, therefore it could work on the European territory, but at the same time there is pressure from the regulators in Europe to say it should apply worldwide. How is this perceived at the moment, without getting into the details because it's an ongoing process, but just to highlight how the tension is coming? Right.
So I think again, it is an ongoing process. So I'm not going to go into too many details, but I think again, it's this sort of two truisms, right? Local law applies, and you need to follow local law. Businesses need to, just like every other one acting in a country, and we certainly take that responsibility very seriously. At the same point, what's at stake here when you're talking about a global product that can reach global people is how do the rights of a sovereign state to enforce their laws in their country for their people intersect with the ability of everyone else around the world who may have different laws, or not just different laws, but competing laws, to, in this case, access information about people, which is lawful and in some cases protected. So I think, this is an issue that we are grappling with right now. I think others will begin to grapple with it before too long. And I think this is a discussion that obviously governments have an interest in and companies have an interest in, but we need to be doing things like this where we're talking as a community, because everyone here has a stake in the outcome of this. And so we can't sort of just do it alone.
Yeah, so that's for one particular category of product that was searched. There's similar problems for hosting content like YouTube or others. Matt, may I turn to you on another type of activity, which is general social media platform, whatever you may call them today. You're from Facebook. How do you see this perspective, and maybe also, as we discussed earlier, in the preparation, make the distinction between the kind of challenges that are related to content issues and access to user data in various cases?
Yep, great, thanks. Thanks a lot for having me. I'm Matt Perrault. I'm the head of policy development at Facebook. So I started at Facebook in January 2011, and it was an eventful week. The first week that I started, Egypt shut off the internet. And so one of the first assignments that I had was to work on the statement that we were going to release when we were trying to figure out what to say about a country shutting off the internet. I think, unfortunately, my tenure at Facebook has been defined in some part on those types of dynamics with governments wanting information from the internet, from internet companies, or wanting to control people's behavior online. I think if you look at any of the indices that have been published about government behavior, the one that came out a couple of weeks ago, and they have a booth not so far from this room, the Freedom House, Freedom on the Net report, all the trends are downward, and the trends have been downward now for several years. The concern that we have, I think, is when there is increasing pressure in the system. In other words, when states are unable to work out how to deal with issues around requests for information and requests for content takedowns, and when there's inconsistency between laws, That increasing pressure in the system, I think, leads to a race to the bottom on human rights. What does that race to the bottom look like? So I think it means a couple of different things. I think it means increasing pressure on companies like ours and companies like Will's. Although if you don't care about pressure on companies, I think there are a lot of other bad things that happen as a result as well. There's increasing likelihood of arrest as laws become overbroad and vague. There's increasing application of extraterritorial jurisdiction, which means that we are faced with challenges in trying to figure out how to comply with local law. And it means that people have less of an ability to express themselves online and are at more risk of having their data provided to governments. As Will said, we try to fight back in cases where we can, but ultimately we often feel that we have to respect local law. So why am I here today? One of the reasons that I'm here today is because this project, I think, is devoted to figuring out how to think about mechanisms for creating race to the top on these issues. And I think that having a multi-stakeholder dialogue where we have members of governments, academia, civil society, companies working together to think about more coherent mechanisms for providing data across jurisdictions that might actually be able to create a race to the top is really important to the future of the internet.
Great. We'll come back a little bit later on another issue, which is the different tracks that are existing at the moment between, on the one hand, optimizing the existing international cooperation mechanisms such as MLATs or cybercrime treaty and so on, and the other track that is more the focus of the Internet Jurisdiction Project, which is on things that do not relate to this and are situations where the content is illegal in one country but not illegal in another one. But we'll come back to that later. Sunil, from both a civil society perspective, and you're coming from India, from CIS, how do you see this problem?
My organization, the Center for Internet and Society, has been working on privacy law in India for about 6 years now. We were part of the committee, the Justice AP Shah committee, that produced a report that will inform the design of the privacy law in India. And the more we spoke to people from law enforcement, the more we realized we also have to think of legitimate law enforcement and anti-terrorism needs. What we hear from them is that the MLAT and LR system is completely broken. It's broken. I just had a brief conversation with a police officer from the UK here today, and I hear from him that it's broken on the other side as well. So the system is broken both from the demand side and also broken from the supply side of information. And the trouble is, it's an asymmetric problem. Not all countries are equally affected by a dysfunctional MLAT regime. The US, for example, doesn't really need information from India, and therefore there are hardly or there are very few MLAT requests coming in our direction, but we have perhaps hundreds or thousands of requests going to the United States. And because the system is broken, we hear all sorts of strange proposals from the Indian government. People are familiar with data localization requirements, mandates on local routing of domestic traffic, and the strangest one was perhaps the proposal that the Indian government made at the ITU, that IP blocks should be allocated based on jurisdiction, so that once we have the IP, we can identify which jurisdiction that IP comes from.
May I stop you 1 second here, because I'm sure in this community it's okay, but maybe for people who will be watching this, there are sometimes use of expressions or acronyms that are very self-explanatory for us. What you're talking about by IP blocks is the attribution of the internet protocol addresses that are used by any device that connects to the network. And this is usually something that is needed to identify who the terminal is, what the terminal is, or who the person is doing. And normally the IP addresses are being distributed on a non-geographic basis, apart from the fact that there are regional registries. By the way, the RARs have a very nice booth just outside of this door. But in some regions, and increasingly, there is a discussion about distributing those IP addresses on a national basis so that they could more directly be attached somehow to a user, just to clarify.
Apart from those type of proposals, there's also discussion about mass surveillance, rolling out mass surveillance, and also implementing filters at the landing stations where the submarine optical fiber cables enter the country. So this is a serious problem, and we need to work on it urgently. I wouldn't be satisfied if the multi-stakeholder model only produced dialogue, because for me, the multi-stakeholder model is only useful when it acts as a self-regulatory mechanism that preempts the need for state regulation. So if you don't want to be regulated by nation states as corporations, either through national or international law, then you can preempt that regulation by coming up with norms and enforcing those norms upon yourselves. And during the process of developing those norms or mechanisms, you must have wide consultation with all the other stakeholders. So that is my understanding of the multi-stakeholder model, and that's why I go to such meetings. Thank you.
Well, one thing I'd like to pick, and we will dig deeper in this. I suppose it's fair to say that a lot of the reactions and the actions of governments at the moment are to adopt measures at the national level because they don't have an international framework, and there's no likelihood that there will be an international framework soon, or even that it is desirable. And so we are witnessing a patchwork of initiatives that are not coordinated and that actually make the problem harder to solve. That's a fair statement. EILEEN, as you're joining and you were opening up something before, we're just going around the table and asking a very simple question on where do you come from and how does this problem of jurisdictional tensions look like from your perspective, from your angle? How urgent, how dire it is?
So first, let me say the work of Bertrand and Paul has been relentless, and it's really important. This is probably one of the most complex spaces there is in internet governance. So from my perspective, this problem flows from a variety of trends. One is the collapse of the online-offline distinction. You know, everything now has a digital connection because of the Internet of Things, the digitization of everything. And the consequences of that is just players who have previously had any role in governance in any space are now in some way, shape, or form rushing into the Internet governance realm. Added to that is from digitization of everything, we all have this enhanced sense of vulnerability. And so that provides extra motivation and justification for many players who rush into this space in the name of security. And often security-related regulations or laws are very broadly and vaguely framed and tend not to be rights-respecting in their design. A third related trend is, and I think this goes to the heart of what you all do, is that domestic laws, which are intended to be applicable to citizens in one jurisdiction, are now having this trans-border effect. That is becoming much more widespread than previously. And the consequence of that is that governments who are attempting good motivation or mixed motivation or whatever motivation to protect the citizens in their own jurisdiction are having an extraterritorial effect on the enjoyment of rights of citizens in other jurisdictions. The toughest case here may be not what we all think of immediately from a human rights vantage point, which normally we think governments in one jurisdiction that are not rights respecting having a negative effect on the experience for others, either in fragmenting the platform or diminishing the experience of rights. The bigger problem and the added complexity may in fact flow from the fact that some jurisdictions are attempting to protect the rights of citizens in their own jurisdictions, good intentions, and in fact raise the bar with respect to human rights, but end up, from the point of view of people in another place, potentially lowering the bar with respect to other types of rights. And the clear example here is the tension that seems to be growing between privacy and free expression. And so I think everybody needs to find a solution, a win-win solution that is respecting of both freedom and freedom of expression and privacy. So the basic worry I have, though, is that all of these laws, the propagation of laws around the world, is potentially having a fragmenting effect on two dimensions. One is on the platform itself, which is so essential to the exercise of all human rights, or on the enjoyment of rights on the platform. And both of these dimensions are problematic. And so that's my biggest concern.
Just for the record, this was EILEEN DONAHOE, who was the Director of Global Affairs at Human Rights Watch. I want to pick on, still in the context of clarifying and framing the problem. What I pick from what you said is the notion that in the connected environment, and it was touched upon already earlier, if a government exercises its perfectly legitimate rights and jurisdiction on an operator that is based in its territory, it actually has a potential impact extraterritorially on the activities of people who are using those operators in another country. I mean, without getting into details, there have been tensions between different regions of the world because of the actions that were done on a DNS operator or on a platform regarding what users are doing in another country. Chris, moving to you, being in the State Department and the state coordinator, the coordinator for cyber issues, how do you see that from the U.S. government perspective, where a lot of the platforms are based in the U.S. and do have those activities outside on the global marketplace?
Yeah, I mean, I think that, look, this is, it's been already remarked that there's been a really...
Sorry, for the record, it's Chris Painter. I should have said that.
Chris Painter. So there's been just a tremendous increase in not just online crime, but more specifically for requests for information, for investigations, not just for online crime, but for all crimes, because everything's stored online these days and everyone communicates online. And to give you some idea, and as you said, a lot of these requests come to the United States for electronic evidence. And during the last 10 years, our mutual legal assistance requests, our MLAT requests, received by our Department of Justice have increased 60%. And the requests for records from electronic communication have increased tenfold. And we really just expect that to continue. And in part, you know, what that means to me is we need to find ways to streamline the existing processes, because you're not going to throw the processes out. They work for lots of reasons, but perhaps they're not as svelte or quick as they could be, while looking at other creative solutions as well. And certainly it has an impact. It has an impact in terms of just the day-to-day workings of people, of law enforcement around the world who are trying to do their jobs and often trying to, frankly, protect citizens and privacy and the stuff they do. It's also had sort of second-order effects, and some countries thinking about doing things like data localization, which is, frankly, just not a scalable solution in any way and has major economic consequences. So one of the things the U.S. did, and what our president directed about a year and a half ago now, is because of those increasing requests to really be committed to streamlining and improving our MLAT process domestically and how we deal with requests that come in. And this past year, we've worked to both modernize the process by devoting additional resources to it and improving the technological tools that are used to respond to and track these requests and streamlining the way it works itself. When I was a prosecutor in Los Angeles, it used to be you'd farm all these requests out to U.S. attorneys' offices, and I will tell you that the first priority of a on-the-line prosecutor might not be that MLAT request from wherever it is because they have trials and other things they're doing, but now it's more centralized in our Department of Justice, which helps dramatically, I think. But then they still have to have the resources to do it, and that's the technical tools.
It's managing the work.
And the resources too, yes, absolutely. So in that process, we've really been focusing on streamlining the process, as I said, and allow our Department of Justice lawyers to evaluate these requests more quickly, and also, frankly, do some training. And this is a long-term effort, and this is something I was involved in back in the G8 days, when it was a G8, and things like our 24/7 network for high-tech crime, and trying to do the very simple thing, it would seem, of making sure that requests that came in are ones that are actually complete, and not just say, tell me everything you know about this IP address, which is neither helpful nor rights protecting. So
what you said is both complete and specific.
Yes, exactly. So that's part of that training effort is part of it too. But I should also stress that no part of these efforts are involved reducing the robust protections for civil liberties applied to the MLAT process, and all the requests are and will be in the future assessed to ensure that they are they meet the U.S. legal standards before they're fulfilled. And that's very important as we go forward in any of this. But I should say, though, is that MLATs are not always the right answer. There are other answers. There's both answers between law enforcement channels in terms of joint investigations and other things that can be done, but there are also creative solutions that might take some of the burden off that MLAT process, and I think that those are worthy of exploration.
In that regard, I want to pick on another clarifying expression. The mutual legal assistance treaties are usually bilateral treaties that link one country and another, mostly, and correct me if I'm wrong, in cases of investigations where there is a request that is being sent by one country to obtain information from an operator or an actor in another country, and this goes through the full country-to-country channel. So India, for instance, has the whole channel inside India that goes from one ministry to the other in several layers of validation. Then it is being sent across borders, for instance, to the US, where it comes to the Justice Department, and then it is validated in the Justice Department and then transmitted to the operator in the country. Apart from the fact that this is a relatively lengthy process, and this is where the streamlining comes in, there's a fundamental challenge, which is that if, when it is examined in the receiving country, it doesn't fit with the legal regime in the country, it is denied. And so one of the core elements is that, and you need to understand this very important distinction, if there is no dual incrimination, like if it is not illegal here and there, then the MLAT system has a limitation. And this is why, in many cases, some of the topics that we're talking about regarding content may not be able to be solved through the MLAT process, even if it is fully streamlined. I just wanted to clarify this because it is a procedure that is not very well known sometimes in this community, and it's important to understand how important it is.
Well, and I'd say specifically, I mean, two things. One, the Budapest Cybercrime Convention is helpful in terms of its MLAT framework, yeah. So that's more of a multilateral setting. And the other thing I'd say is, and there's good reasons for that protection. Now, you have different ways of looking at dual criminality, but for instance, if a country comes to the U.S. and says, we want information because someone has criticized our prime minister, president, king, whoever, because it's against the law in that country, we're not going to comply with that, and for very good reasons, and also for rights protecting reasons.
Absolutely. We're waiting for another panelist who is from the OSCE, Frane, who can provide another element. But as we're at half of the hour, After this first setting the scene, if anybody in the room or around the table wants to provide additional elements, and EILEEN, without putting you on the spot, if you want to contribute, you're highly welcome.
Thank you very much. EVANA THACI from the Council of Europe. I work with the Media and Internet Division. We have been engaging in the last 5 years or so with the issue of cross-border impact of state action with regard to the Internet across borders, across jurisdictions. And recently we adopted a framework of principles about how states should measure the impact of the laws that they are adopting and the policies that they are adopting with regard to, for example, freedom of expression or laws that impact freedom of expression, and to make sure that these laws do not have a cross-border impact. But I'd like to go back to this, to focus on this notion of cross-border impact. The challenge is known to all of us. I mean, we accept this challenge that what is happening in one country may have a negative impact in another country. But as far as freedom of expression is concerned, for example, the legal frameworks to avoid that impact may not work unless there is a harmonization of understandings and laws as to what is illegal content, and that harmonization of substance is very difficult, because the understandings of unlawfulness of content is very diverse in many member states. For example, of the Council of Europe, we have 47 European member states. So that is not very likely to happen soon, that harmonization in...
And I would, sorry to interrupt you, but I would even ask the provocative question, is it even desirable that there's a harmonization of the criteria on speech? I see negative noting around the table. So how to handle it?
So what is the fallback solution here? What is the option? I think procedurally, I think we should look at the procedures. Exactly at this cross-border cooperation procedures, especially with regard to blocking and filtering, but also removal of content. What is hate speech in one member state, for example, will not necessarily be hate speech in another member state. What is content considered immoral or against the morality of one country cannot be considered illegal in another country. So the idea is to find a mechanism, a procedure which permits a state to control, to restrict content within its borders without impacting across borders. But what is the procedure? And I think this is the kind of reflection we should be having.
Actually, are there other comments around the table? If you want to chime in, don't hesitate to raise your hand. It's actually a very interesting segue, because if you look at the title, it's transnational due process. Transnational is clearly the thread that is underpinning this whole discussion. I mean, the jurisdictional issue, if we're talking about the responsibility of one government on its territory, it's the traditional international law, there's no problem. The problem we're confronted with is this conflict of law, this tension between the two dimensions. And so what EILEEN is producing is this natural segue of the distinction between substantive convergence or substantive harmonization, which is typically what is done in the MLAT process, in the Cybercrime Convention, all the situations where there's a convergence of the topic and the procedures are derived from it. And the situations that we're also dealing with here, where there's no harmonization in the substantive, that is probably likely, even if the categories might be an element of common element. But going into the process. EILEEN, do you want to chime in?
Yeah, I think you raise a really multiple rich questions. And from a human rights point of view, what I would say is that variability of laws is not in and of itself a problem. In each jurisdiction, those laws should be evaluated based on their adherence to universal human rights principles. But the complex part happens in the extraterritorial effect. And this is where variability is having consequences for other things that really matter to the exercise of human rights, which is the platform itself and the ability to send information globally. So harmonization isn't necessary everywhere, but it may be required with respect to this extraterritorial effect to meet minimum human rights standards. It's not the full game everywhere, but there is a minimum basis that everybody has to meet, and that may end up becoming the best rule for the extraterritorial effect. And that, I will also just say, instinctively, I think this transnational due process model that you're working on has the potential to do some of the work to the extent that process questions go to substance. It helps. It'll move partway there simply through the due process aspects of it. Maybe not the whole thing, not all of the substantive conflicts, but it could be substantial in helping solve.
In this regard, staying for 1 second on the procedural convergence, and the notion is probably more interoperability than harmonization per se. It's standardization of process. Going to the criteria that Chris Painter was mentioning earlier, like that the request needs to be complete and specific. There are other elements such as the request should be based on valid law in the country, that there should be proportionate, that there should be justified, and so on. There's an element that has emerged in the discussions that we facilitated, which is that the way the requests are formulated are all over the place. They can be very informal, they can be not structured. And the notion that there could be formats for requests is one component of interoperability. And maybe I can turn to Matt, because there is a strong convergence between what the major platforms have progressively established, because they have portals, they have forms, and actually DNS operators have usually forms and procedures as well. Can you tell more about the benefit of streamlining or taking lessons from those experiences to produce shareable standards?
Yeah, so I think it's certainly really important that we have a set of best practices that companies, governments can think through in terms of how they process data and to ensure that they do it efficiently and consistently with human rights law. But as EILEEN said, I think it's not necessarily the case that harmonization is a good in itself. So I think it's useful to have best practices out there and then to try to operate on a case-by-case basis to think about how to maximize decisions in terms of human rights value. I do think it's also important that we think about, in thinking about how to address this issue, that we don't think that the only option is to solve all of it at once. So I think the kinds of cases that Chris described, where you're using the MLAT process to kick out speech cases, those are really important cases. But it might be that we could have a system where, in some cases, there are better ways to transfer information across borders that are totally consistent with human rights, and that by responding to those legitimate cases with answers more quickly and responding, because there are many cases now where U.S. companies aren't permitted to respond, it actually enables us to say no in the cases that really raise significant human rights issues. So I think it's important to not let the perfect be the enemy of the good, and to think really clearly about decisions that we can make, sometimes on a micro basis, to improve the system overall.
Without getting into details, there are basically 3 types of requests that have been mentioned in passing, but I want to highlight them as a structure of the discussion, or even for further follow-up for people who want to see that. You have requests that may come across borders for domain seizures or suspensions. These are addressed to domain name operators. They can be registrars or registries. And there are requests for the takedown of content or the withholding of content. It can be a tweet, a blog post, a video, or anything, and this is usually addressed to online platforms and user-generated content platforms. And the third category is the request for user data or user identification, which is a very important thing in the criminal processes, but that can be addressed to actually a much broader range of actors. It can be the technical operators, but it can be the telecom companies and others. So it's important to have in mind when we're addressing all those issues of transborder requests, that there can be requests to different types of actors and for different types of issues. I mean, we're talking here more about issues that are related to content, to free speech, and so on, but there are many other topics that can be addressed almost in the same kind of mental framework, be it about fake pharmacies or fake pharmaceuticals or anti-phishing working group when there's phishing, botnet malware, and things like that. So in terms of framing the debate, it's important to think about the qualification and the typology of the types of requests, the types of users, the types of topic and rationale is an element of structuring the framework. Good. And please tell your name.
Thank you, Bertrand. My name is Walter Natris. I can't really say that I'll be speaking on behalf of the IGF Secretariat because that is impossible, but they hire me to do two best practice forums, and one of them is on the mitigation and regulation of unsolicited communication. What I can do is just highlight some of the things that we've been working on this year, and one of the things that we recommended in the report last year, because this is the second consecutive year it's running, was simply that transnational cooperation between different sort of law enforcers or even same sort of law enforcers is very hard. You're discussing that already, but this year there's something in there saying it's about time governments step up on this process because the world is changing so fast, as you are all saying at this moment, and we've got something like that in the report. But what we'll be focusing on this year is we're not going to do best practices again because they're all in there and the world has not changed that much this year. We actually went looking for what is working. Can you give us case studies on things that are successful? And what we've been noticing is that there's a lot of activity, public-private, but also private-private, on how to deal with these sort of topics that don't need any transnational due process because they are actually dealing with it, whether it's a national DDoS mitigation center in the Netherlands that they've actually built totally private without any government interference, but it actually helps making your country a lot safer and a lot less attractive to other bad, nefarious purposes that are working there. So you don't need a government to actually come into action if there's a will and leadership to actually execute something like that.
Just one clarification. The term transnational is purposefully intended as not meaning international. It does mean different types of involvement of governments. There are places where they are needed and places where things can be done on a separate basis. So it's not an intergovernmental discussion. I think it's the core of the approach to. Thank you for clarifying that. It's important.
That's what I gathered. That's why I'm putting this sort of there. But I want to say is there are a couple of other examples in the report that we're going to publish, I think 2 or 3 weeks from now, which may actually be good examples how to work on a transnational basis between companies and not just national. If there's a will and a leadership to tackle a problem, then actually maybe the government only needs to facilitate and the companies can take care of it themselves. And that's what I want to bring from the IGF process and our outputs.
I'm glad you mentioned, and I can give you the floor now, but I'm glad you mentioned law enforcement agencies because Interpol and Europol and law enforcement agencies are participating in the dialogue process. And what is striking is that be it for intergovernmental organizations or for those specific groups like Interpol and Europol, if they are only among themselves, they have difficulties finding the solution, and this is one of the benefits of having the interaction with the private sector as well. Please. And please give your name for the record.
My name is Grace Mutungu from the Internet Society Ambassadors Program. I have a question or concern that because the standard being talked about here is human rights, But in Africa, there's also the notion of people's rights. And so especially to the companies that are now coming to Africa, because we are now saying that Africa is rising, Google and Facebook. My question is, to what extent in your operations and in this kind of requests do you consider the question of people's rights, which sometimes, like in the cases of hate speech, are taken to be slightly more important than individual human rights? And also considering that there is not so much national legislation, or that national legislation is now being developed in most African countries, to what extent are you participating in the development of this legislation and in the policy processes?
If I understand correctly, the distinction you're making, and it's an important one, it's just like there's an element of human rights regarding discrimination against individuals for race, gender, and so on. When you talk about hate speech, there can be dimensions of hate speech against a particular community. That's the right understanding. Maybe it's interesting to ask the platforms, because in this regard, they have developed a lot of elements in their community guidelines regarding precisely the treatment of discriminatory things towards gender, race, and so on. Is that taken into account, this distinction between what could be harmful to one person or what could be harmful to a group? That's a good question.
Thank you. That's a good question.
Yeah.
And I apologize because after I answer it, I'm going to have to run to another session. But
9 minutes.
But I'm sure if people have other follow-up questions, please grab me in the hallway or pass your information to Bertrand and you can get me. So as Bertrand says, this is definitely something we take into account when we're looking at things like, in Google's case, the YouTube platform, where there's, from the beginning, YouTube was intended to be a place where there was going to be a sense of a community. And so there was, at the beginning, something called the community guidelines, which are updated every now and then, and they're public and you can go and look at them. And essentially the principle there is that when you upload content or you're commenting on that content on the YouTube platform, you're subject to these guidelines. In each video or in each comment, users have the opportunity, whether or not they're the user that's affected directly or not, have the opportunity to sort of flag that content, and each one of those is reviewed individually. I think that, broadly speaking, we're talking about, again, the types of things Google has done, which are the only ones I can speak to, are the sort of, our recent policy about revenge pornography, for example, where, there's an argument, right, that, there's a free expression right, and if it's not otherwise criminalized, and in many jurisdictions it is still not, to let that content go. But we made the decision, given the impact that this was having to individual people, to have a policy that would ban that kind of content. So I think at a meta level, what I would say is that, we do think about these things on our platforms. It's, as with everything else, it's extraordinarily difficult, though, which is why it's useful to be in sessions like this and in projects like this where everyone can raise those concerns and we can think about them thoughtfully.
Matt?
Yeah, just a brief response. I'm really glad you raised the question. We actually, sorry?
No, it's a very good question.
When we think of human rights, we actually take a very broad view of human rights. So we're not thinking just of political and civil rights, but are also thinking about economic, social, and cultural rights. And so the community rights that you mentioned, I think, are something that are very much top of mind for us. On your latter question about policy developments throughout Africa, we are paying very close attention for the reasons I described in what I said at the outset. The trends, we are concerned about global trends in free expression and privacy, and obviously that's quite bad news. It's good news for the continued employment of the Facebook policy team, so I'm glad that I'll continue to have work to do. We also recently hired a head of policy, Abele, who's actually has been here throughout this week, and part of the reason she's here this week is because of the specific concern that you raised, to make sure that it's clear that we do have an interest in protecting the free expression and privacy of people in Africa.
If I may piggyback, and we will close because we have 6 minutes, your question raises two elements. One is the definition of the rationale that are the legitimate basis for transborder requests. And in as much as we've talked about harmonization or streamlining, one of the objectives of what we're discussing here is to not just automate and simplify, is to raise the bar of due process in terms of the content of the requests and the rationale and the justification. And one element that has been mentioned right now is that in the general landscape of norms, you have international norms, you have the national legislations, you have the jurisprudence, and increasingly you have the terms of service or the community guidelines of the different operators. And part of the work that is underway is to try to see what is common from those elements and how they converge. The second element is, to answer your second question, as the Internet and Jurisdiction Project was certainly not impacting or influencing or intervening in any legislative discussion. We're a neutral facilitation team. But one thing that is in the context is that if every single national country develops national laws in a completely uncoordinated manner, the danger that they are not coherent and that they will actually make the problem harder to solve is extremely strong. And so that's one of the messages we're sharing. So we have 5 minutes left, and so I think the best way to finish is maybe to go around the table in the reverse order and ask each of you, given that there's no way we can sort this problem in 1 hour, what is the element or the additional thing that you would like to highlight, given that this is an ongoing process? And if I may ask people in the to switch to the next slide, please. Can someone ask them to switch to the next slide? You have the address of the process. EVANA, do you want to start? Maybe one brief comment. We have 4 minutes, so if each of you can say one thing that you would like to send as a strong message on this topic.
Not as a strong message, but perhaps as an additional message to what I said. I think it's important to pay attention to what the international courts are going to say on these issues. For example, there are cases now pending before the European Court of Human Rights, one versus Austria, one against Slovenia, and the key question there is with which authority can public institutions, public authorities request subscriber information from internet service providers? So it's useful to pay attention to that to those developments. Another case which of the European Court of Human Rights, a judgment which was issued earlier this year, the case of Delphi versus Estonia. It's interesting because in that case the court chose very explicitly not to deal with the jurisdiction issue. There was a question there whether the e-commerce directive had been the good choice of law made by the country, the respondent country. But the European Court of Human Rights said that this is totally left to the discretion of the country. So there may be principles emerging out of the jurisprudence of the European Court of Human Rights. Thank you.
Thank you. Courts are going to play an increasing role. Chris, one.
So I think, this is a very interesting discussion. I think that, there's going to be a lot of things that are going to happen over the next few years, and some of them are going to be better streamlining and coordination among governments, certainly, and some of them are going to be some of the creative solutions the multi-stakeholder community is looking at, which really have to be based on some principles being put into practice, and I look forward to those, that development, because it certainly is a big issue. But it's important for this community, this multi-stakeholder community, to look at these issues and make sure that due process and human rights are protected while legitimate law enforcement and other concerns are addressed. And so, thank you.
EILEEN.
2 things. One, I love your clarification, not necessarily harmonization on the extraterritorial space, but interoperability. I think that's a very useful distinction that I hadn't thought of. And transnational as opposed to international. But just one comment on your process and the value of it, bringing together. It is a genuine multi-stakeholder conversation, and for everybody in their own space, understanding how this is already happening by default because we're not always talking to each other, and understanding the tensions and stresses that individual players are already being faced with. so that, and because it's not going to be largely only governments, it is the private sector has this on their plate already, and each one is addressing it slightly differently, and so having the human rights community involved is very important.
Sunil.
I'd just like to repeat myself that with every passing year, the problem is only getting worse. I spoke to some police officers at a cybersecurity conference in Bangalore a couple of months ago, and they said because MLAT requests were not being expedited by the American government, they would unnecessarily introduce falsehoods. They would claim that the terrorist that they want information about is also planning an attack on American soil. This reduces the quality of intelligence. So there is no point coming to the IGF and similar fora and hyperventilating about the balkanization of the internet if you're not going to develop mechanisms and solutions to address the legitimate law enforcement needs of countries such as India. Thank you.
And it needs to be noted that this is a statement by a civil society group that is defending a lot of other issues regarding freedom of expression and so on. So I think it's one of the benefits of the IGF to have that kind of statement, actually.
So it's been great to be here this week and get a lot of feedback from this community. I'm looking forward to getting more of your feedback and how we can go from a race to the bottom on human rights issues to a race to the top.
Mark?
Yeah, we're talking about incredibly complex issues here, and I believe that complexity necessitates a multi-stakeholder process to identify solutions. And that's what I think the beauty of the Internet and Jurisdiction Project is, and it's why, because of its multi-stakeholder structure, that's why we believe it's the best and the most effective forum for discussing issues this complex.
So, with that, I thank you very much. I want to wrap up with just a few things that really were clearly confirmed in this discussion. One, it's an element of urgency. The jurisdictional issue is that increasingly at the core of internet governance problems in many, many topics. And as has been said in many instances, the problem is really getting worse. And it is probably one of the biggest threats to the very fabric of the internet as we know it. This process is one, as has been kindly said, that brings the different actors together. I encourage you to go to the site. We're producing every month a newsletter called Retrospect that documents cases of jurisdictional tension across the world to paint the landscape and create an evidence-based process. And I hope that if you have any questions or if you want to contribute, you won't hesitate to contact us. You have the annual report here that we produced at the beginning of this year that has an explanation of what is today the proposed architecture for a due process framework for those issues. It was not possible in this amount of time to detail it, but I encourage you to have a look, take this report or spread it online. And thank you very much for having attended, and thank you very much to the panelists for having taken this hour in their time. Thank you. It was good. Thank you very much.
Thank you.